Kevin Hunter with Jeff O'Brien on the Business Forum Show, and we're going to talk about buy-sell agreements. And as you referred to this before the show, Jeff, this is kind of the business prenup.
It is. I refer to it to my clients as a business prenuptial agreement. Just like with a marriage, you have a prenuptial agreement sometimes to try to have a smooth, orderly transition from things if the marriage ends. Same thing with a business. If you have, this is could be a marriage in some respects for business purposes, and you want to have a smooth, orderly transition to how it ends.
Yeah.
Because you may have money involved, you've got employees involved in the business. You want to, if the owners decide that for some reason that someone's going to go, you want to be able to have that happen in a nice, orderly process.
Mm-hmm.
And because I've had shareholder lawsuits.
Mm-hmm.
Our firm has represented a number of clients in shareholder lawsuits, and it can be 5-6 figures of legal fees. Now,
Pretty nasty.
we love, making money, but I'd rather have a business client that has something in place, a mechanism to have a nice, seamless transition,
Mm-hmm.
so that they stay in business and we can, keep that client for a long
Well,
time.
one thing I like about the distinction of calling it a business prenup is, when does a prenup happen in marriage? It's before the marriage.
Right.
And so when we're talking about buy-sell agreements, you'll see these happen in several cases, at least I've noticed, where a buy-sell agreement is something that's drafted much later than the early stages of the business agreement. And to me, that's a mistake.
Well, it depends on the situation. A lot of times, a lot of my clients, if we're starting out as multiple owners, whether it be shareholders in a corporation or members of an LLC, we do draft a buy-sell right out of the gate, and that's kind of our standard practice.
Sure.
A lot of times, depending on how the business goes, someone may have started out as a single owner business. Now, maybe 3, 5, 7, 10 years later, they're bringing in a partner.
Mm-hmm.
Okay, now it's the time to have, because you obviously don't have a buy-sell agreement when it's just yourself.
Sure.
You'll use your estate plan to provide for how your ownership interest is handled, on your death.
Mm-hmm.
But when you bring somebody else in, now you have the potential issue. Now you have to put one in place.
Mm-hmm.
Sometimes it's kids, inheriting the shares from dad,
Mm-hmm.
and now because you've got more than one, we need to do something. So
Yeah, so I guess what I was referring to is not necessarily in the infancy days of the business per se, but at least in the infancy of when a buy-sell agreement would be appropriate.
it's the best course of action would be to get a buy-sell agreement in place as soon as possible after there are multiple owners in the business, because everybody's on the same page on day one.
Mm-hmm.
And that's the time to agree on all this stuff, and not 5-10 years when there's money involved. People there may be some issues that arise, and that's when you don't want to have all these issues kind of floating around to be determined, and then it ends up in hands of lawyers to and in the court to sort it out.
And people's ability to be reasonable is so much greater in those early days when there isn't really any history there. It was kind of an interesting thing that a well-known business coach mentioned, and he said that when he's had partners, or if there have been multiple partners involved in an organization, have them talk about put together a report on basically what they do and what they think of their contributions to the bottom line. And he said, interestingly enough, when you add up all of these contributions, it's about 150% of what is actually happening. So you're going, who really is doing what? So that, drafting a buy-sell agreement at some later stage in a partnership can be really difficult to do, because people are looking at what their contributions are, and it may or may not be realistic.
Well, you bring up an interesting point, Kevin, because I've had buy-sells. We can talk about the different triggering events that, because what a buy-sell is there's certain events that, if they happen, gives the right to the other owners or the company to buy the owner's shares who's subject to the event. Okay. And what you just mentioned in terms of contribution to the business, I've had some situations with clients where if everybody has a predefined role in the company, they're all going to be active in it, they're all going to be performing certain duties.
Sure.
They'll specify what each one of them is going to be doing in the buy-sell agreement, and to the extent that they're not doing their duties any longer, that can be a triggering event for the buy-sell. Obviously, there's some issues there. They may have a dispute over whether or not they're doing it, but but still, that's one way of ensuring that people carry out their tasks by putting their shares on the line if they don't.
What do you think in some cases where business owners either neglect to do a buy-sell agreement at all or it's delayed much later? Why do you think this is something that is sometimes overlooked?
Because typically people and I work with a lot of closely held businesses, and that's where these agreements come up. I think you know a lot of times in closely held business you might be going into business with friends, family members, and you don't think, well, how could we ever not be on the same page? Just like
Sure.
we don't need a prenuptial agreement because we're never going to get divorced. Same kind of thing. So everybody there's a lot of trust involved at the outset, but you know, money and success changes people, and the extent that or on the vice versa, if the business is not doing well, there may be some, you know, well, it can't be, like you said, it can't be me. It must be somebody else, and that's when you get into problems. And so, you know, it's not in its infancy. Nobody can foresee not being on the same page as their partners down the road. Then it's too late. If there's nothing in place.
What do you think of as the major benefits of a buy-sell agreement? Beyond some of the real obvious ones, what do you think are some of the big benefits of a buy-sell agreement?
The biggest benefit is it provides a clear understanding to everybody who's a party to it what's going to happen if certain things happen. What happens if someone gets an offer from a third party to buy their shares? The other, you know, most buy-sells will provide that the other owners give the right of first refusal to buy out that person. What happens if somebody gets divorced or files bankruptcy? That's considered involuntary transfer, and the other partners may have the right to buy them out. What happens if someone dies? Do you have the right? Is it a mandatory purchase? Do you have life insurance to fund it? Or you have the option to purchase? What happens if somebody is disabled? And what does disabled mean for purposes of the buy-sell? You know, all those different things are triggering are events that people have to consider.
And when you think about having a game plan, what it does to reduce stress is huge.
Yes.
Because it's always a stressful situation when you have a buy-sell type situation being triggered, and if there's at least an agreement in place to say, here's what our course of action is, makes a heck of a lot of sense.
Exactly.
Kevin Hunter with Jeff O'Brien here on the Business Forum Show, chatting about buy-sell agreements. You can contact Jeff O'Brien at jobrien@bowman.com. Again, that's jobrien@bowman.com. Again, Kevin Hunter with Jeff O'Brien on the Business